Welcome to another edition of FH&P Lawyers Law Talk. I'm Clay Williams. I'm a partner here at FH&P. I'm the host of the program, and we've got a great show for you today. I've got my special guest, Abu Khurana. Abu is an associate at FH&P. And how long have you been here for?
Probably roughly about 3 years or so.
Fantastic. And I think this is going to be a really interesting topic for a lot of our viewers. It's very topical because, you're getting a lot of calls about the Residential Tenancy Board. And is it mainly about, evicting tenants that are not paying or behaving poorly? Or is that what you usually deal with?
There's a variety of different issues. A lot of them have to do with landlords wanting to evict tenants, like you said, for being late on rent or unpaid rent, or if they're causing some other issues with the tenancy and essentially they're wanting to get them out. I know these days it can be pretty difficult to do so without getting yourself into trouble. So you want to make sure that things are done correctly and they take time and it's a bit of a process.
Well, we're hearing about it. I read about it on Castanet and other places all the time about landlords are going a long period of time, sometimes without getting paid. And, that's tough, man.
Yeah, it's tough in these economic situations too, right?
You just try and get ahead and buy a property and then, people don't pay. That's tough, man.
You're on the hook for your own mortgage and then your rental property as well. So
yeah. So tell us, why don't you start and give us an overview?
Yeah, so there's the Residential Tenancy Act, which basically governs these rental agreements and these rental properties. And then there's the Residential Tenancy Board. That's where essentially these disputes are brought up. So for example, if you're wanting to evict a tenant and then you issue an eviction notice and then the tenant goes and disputes that notice, then there's a hearing with the Residential Tenancy Board, right? So the process with that is you essentially serve the tenant with an eviction notice. You put your reasons on there, why, what are the grounds that you're trying to evict this tenant, and then the tenant will have a certain period of days to dispute, just depending on which eviction notice, typically 10. And then from there, they'll serve you with a application for a dispute resolution hearing. And then with the RTB too, it is very tight with deadlines. So typically the applicant, so the one who's making the dispute, they have to serve and submit their evidence 14 days in advance of the hearing. And then the respondent, which is typically the landlord when the eviction notice is served, they have to submit and serve their evidence 7 days before the hearing.
And so this is something that you help with?
Yeah, so this is just to ensure. So there's certain service procedures, right? So if you paste it to their door, your evidence package, it's considered served 3 days afterwards. So you want to make sure you've served it by the applicable deadlines, because there's a chance if it's not served in time, the arbitrator might not even choose to look at your evidence. So it's pretty strict with that sort of stuff. So.
Do they adjourn the hearing, or do they just say, you didn't do it right? So.
You would have to have some valid grounds to adjourn it. If you've done it based on your own negligence, more than likely the arbitrator is not going to adjourn it. They might consider your evidence, but it just depends on who you're dealing with that day and if there's a real prejudice to the applicant, right, or the respondent, whoever's served late, right?
Okay, so I think our viewers would be interested in knowing what goes on at these things. Are they done in person, or are they done on video or by telephone? How are they conducted?
Yeah, so typically with the dispute resolution hearings, these are done through phone call. So what happens is you're given a phone number you got to call into at a certain time. So that's the hearing, and then with that. You call in, and then the respondent calls in as well, and then you're taking an oath saying that you're going to be telling the truth, and then from there, the applicant starts. They go in there, they talk about their evidence, they talk about why they're wanting to either dispute the notice, and then from there, the respondent gets the opportunity to respond, and then what happens after that is the arbitrator will essentially talk about the file, the case, and then they won't make a decision right away. So this is where like the process comes in. So they can take up to 30 days after the hearing to effectively make a decision, right? So I mean, typically you get it within 2 to 3 weeks, but like sometimes it can take a bit longer, right? So it's a lengthy process, as you can imagine. So I mean, it's frustrating for landlords because if they don't issue the eviction notice properly, and then they go to this hearing and the arbitrator is like, yeah, your eviction notice isn't valid. You've done this incorrectly, or you didn't include this. You waited a month for the hearing, and then you're waiting another month for the decision just to say, oh, we're not going to agree that your eviction notice was done properly. So we're essentially dismissing this eviction notice.
Could you file again?
You can file again, but then you're looking at another month for a hearing and then another month for a decision. So just as you can imagine, it can cause some delays when you're trying
no rent, 2 mortgage payments.
Yeah, so it's like you can cause some delays for sure.
Right.
And then it's a process that you got to make sure you're looking into the details and looking into the deadlines and whatnot, and ensuring that things are getting done on time and correctly, right? So
yeah, well. So what is it? Tell us what you do. Like, what is your role in all this?
Yeah, so I mean, with this, typically there's different situations. So I mean, there's situations where clients will retain me prior to the hearing. So they'll be like, oh, I have a hearing in a couple weeks. Can you help me prepare the evidence? Let me know what I need to submit as evidence, and essentially attend the hearing for me, prepare written submissions. So that's the kind of work I would do. I mean, and there's also situations where a landlord will contact me and say, hey, this tenant's giving me some troubles. They're not paying rent. Can you assist me with getting them evicted, right? So I'll take on the file from the start, and essentially I'll issue the eviction notice, serve the eviction notice. I'll work with the landlord, get whatever evidence we need, right? So that evidence can consist of bank statements or any pictures or text messages demonstrating that rent has been late or unpaid. And then we submit that all. And then I also like to include some previous decisions from the RTB. So then that way it gives the arbitrator a bit of a guideline, because if they're going to rule in, if they're not going to rule in your favor, then they look at those decisions, and you got to point out that, hey, this is very identical to my client's situation. So I don't see why you wouldn't rule in this favor, right? And then basically from there, we submit the evidence, serve the evidence for the client, attend the hearing, and then once the decision's out, we just let the client know of the next steps.
You know, one of the things that I've noticed is how, like, we're trained in legal proceedings and what is relevant and what is needed for the issues. I'm always stunned at how, you know, for those people that are looking from the outside, they might not know what they need to present, or they may think that they need to, that something would actually help that doesn't, you know. So so that's when so you'd help with the submission package and doing the actual submission.
Yeah, so I'll give some guidance along the way. I'd be like, hey, this is what I'm needing from you. I'm gonna need bank statements, and then I'll have a chat with the client, and I'll say, give me a background of what happened, and then I'll do some written submissions to include in our evidence, and then any other sort of evidence that would be helpful, like I mentioned, emails, text messages, demonstrating that rent was paid late or if it was unpaid. And basically from there, I put that all together, submit it all for the landlord, and then it's less stress on them, right? Because a lot of these people are working 9-to-5 jobs, right? And they're busy with their families, their kids. So it can be a stressful situation to find yourself in.
Well, and so we've touched upon that you better get it right the first time, because if you don't, it's going to take at least a couple of months, it sounds like, to get it back to where it was. But as I understand it, there's some really, really serious financial consequences if if you do it wrong as well. So tell us about that.
Yeah, so one of the things is, I know in the past people may have thought that, okay, like I'm gonna issue a eviction notice. It might not be that the tenant's not paying rent. They just feel like, okay, like the rent that I'm receiving is quite low compared to the market, right? And I mean, with that being said, landlords are like, okay, well, I want to get this person out. So in some cases, people will issue a eviction notice for owner occupancy.
And I guess just back you up here.
Yeah.
That's because in British Columbia, there is rent control. You're only allowed
a certain amount per year.
To increase it by a certain amount.
Exactly.
So, but if there's a new tenant, that resets at market.
Yeah, exactly. You can, if there's a new tenant, you can increase your rent, and there won't be any issues with that. With that being said, with the owner occupancy eviction, there's been a lot of trouble with that one, right? So, I mean, what happens is landlords might think that, okay, I'm going to issue an owner occupancy eviction notice, and I'm going to get these tenants out of the property. And I've seen scenarios where the landlords will re-rent the property within 5 months, 4 months, 6 months, right? And I mean, when you do that, effectively what happens is you're not abiding by what the notice you issued says, and then the consequences of that would be the tenant that you booted out, they can make a claim against you for 12 months of rent. So as you can imagine, that can be quite a bit of money, right?
That's a huge financial hit.
And
wow.
Yeah, and it's very unfortunate because there's like, once you do that, it's very difficult to even overturn that, just because you're not acting in accordance with the RTA guidelines, policies, and whatnot, right? So I mean, it can be a big financial burden, and then people will come and say, "What do I do?" Right? So I mean, you got to understand the legislation and the RTA
come
policies.
See you before you start the process, maybe. Right?
Yeah, no, for sure.
So, because that's a lot of money. Holy crow!
Yeah, nowadays you got to wait 12 months, a minimum of 12 months before you can re-rent the place. And then in addition to, you can't just leave the place vacant.
Well, I was going to ask that.
So that's the thing. Like,
say, I was going to move in.
Yeah, like, I was there every Saturday, right? That's not going to work, right? So I mean, I've had some scenarios where the tenant will drive by the property, and they'll take pictures, and they'll be like, "Oh, like no one's in there." They'll walk outside the property, go to the windows, no one's on there inside the property. And then another thing is, like, the landlord might not know that they can't do this. They go and post this on Facebook Marketplace at a higher rent. And then the tenants take that evidence, make a claim with the Residential Tenancy Board, and then effectively seek that 12-month compensation of rent.
And they'll get it.
They'll get it too, yeah. So I mean, as you can imagine, rent, like a couple $1,000 a month, 12 months, like 24,000 right there.
And there's so tell me a little bit then about, a landlord can't just willy-nilly evict a tenant for whatever reason, at least in BC. So it's pretty restricted on the grounds that they can evict a tenant. What do you talk about that a bit?
Yeah, so I mean, where there are situations where a tenant has been problematic, I mean, some of the ways landlords can evict a tenant, which works pretty effectively as well, would be, the first one would be late rent. A lot of people don't know this, but essentially, if a tenant doesn't pay on the first, if they pay on the second, that's still considered late rent, because typically in these residential tenancy agreements, it says rent is due on the first. Obviously, that's subject to what you put in the agreement, but most people are putting in the first. But if you're paying rent on the second, that's considered late, right? So I mean, if you pay rent late 3 times within a year, typically, based on the case law out there and the previous decisions, you will get evicted, right? So, I mean, it's obviously up to the arbitrator's discretion, and if there's any other additional factors to why the rent was late. So that three times in a year is important. And then another thing as well is, if the tenant goes and essentially pays you on the second, and you just accept it without saying anything, you're effectively almost agreeing to accept rent on the second, and it's not like you're taking issue with it. So one thing that I tell clients, it's important to, essentially, when you receive rent late, you need to send an email saying, "Hey, I've received your rent late. essentially rent is due on the 1st, and going forward, please pay me on the 1st. This is considered a late rent. So basically with that, it indicates that it is due on the 1st, you're late. And then if they do 3 times in a year, then you can apply to the RTB for eviction notice for breach of the residential tenancy agreement.
So that's good advice to tenants too.
Yeah.
You better pay that rent on time.
You gotta make sure to have it paid on the 1st,
Yeah.
and no late rent.
Yeah.
For sure.
And so what are some other ways that landlords may want to evict a tenant for?
Yeah, so I mean, some of the other ways would be like unpaid rent, right?
Well,
so,
that's the classic.
Yeah, that's the classic. So I mean, with that one too, that one's a 10-day notice, right? So it's a 10-day notice for unpaid rent.
Mm-hmm.
What happens with that one is, although it is a 10-day notice, the tenant only has 5 days to either dispute the notice or effectively pay the rent. If they pay it on the 6th date, once again, you gotta send a message to the tenant and say, hey, I'm accepting your rent for the occupancy of the property only, and my eviction notice is still in full force and effect.
Oh, that's a good tip.
Yeah, that's a good tip for
so
sure.
You can still take the rent.
Yeah.
As long as you let them know, it's too late.
Yeah, so basically you've gotta outline like this payment's accepted for use and occupancy only, and it doesn't reinstate the tenancy or waive any prior notices or rights. So effectively you're telling the tenant there that we're accepting your rent for use and occupancy, but our notice is in full effect still, right? So
you got to get that notice out first.
Yeah, so you gotta send an email,
and then the tenant pays.
Yeah,
but you want to tell them no, it's too late.
If it's beyond the 5 days. Correct.
I see. Okay.
Yeah.
Okay.
So I mean, if you don't do that,
Mm-hmm.
then it can be assumed that you're effectively you've reinstated the tenancy. So some arbitrators will take that position. Tenants don't know that, right? And the landlords don't know that, and effectively they just accept the rent and think, okay, well, this is still going to go ahead. When it comes to the hearing, it's a different story.
Or
right?
I've heard other, just don't accept the rent at all. So that is a good tip that you can.
Yeah, no, for sure. So I mean,
as well.
You still want to accept the rent because you still got your bills to pay, right? So right, that's very helpful in terms of being able to still move forward with your rent payments, but effectively still pursue that eviction notice.
All right. Any other situations that you see where tenants are facing eviction, and for what reasons?
So I mean, there's always like a few others. So I mean, obviously there's like if you're causing a nuisance or if there's illegal activity at the property, right? So those are big ones as well. So I mean, with those ones, it's important for the landlord to keep everything documented. You need to issue warnings, right? So I mean, if there's noise complaints or anything along the lines of that, it's very important to document things in the residential tenancy with the Residential Tenancy Board, because all these things can be used as evidence down the road.
Right.
So I mean,
and if you don't take an issue with them, well,
yeah, then if you've done it once, but you've maybe like verbally warned them a few times, like it's not in writing, so it's a little bit harder to prove, right? So I mean, another important thing with that one is you might have a couple people, like if you have a duplex or something and the neighbor's being loud, right? And the one neighbor who isn't being loud is texting you saying they're being very loud. So then you need to go then and give a warning to the tenant who's being loud, right? So I mean, with that, you need to make sure to keep those records. And then if you're issuing these warnings, you can then use those warnings, the text from the other tenant who's making these complaints, submit that as your evidence, and you have some grounds for eviction, right? So
I see here you've given me a practical tips section here in your notes. So why don't you tell us what that's all about?
Yeah, so with the practical tips there, so there's a few things. So I mean, one of the big things I would mention for landlords is a condition inspection report. So a lot of landlords don't know this, but when at the start of the tenancy, people think, okay, I'm going to take a damage deposit and that's it, right? And then if there's damage to the property, I'm going to withhold that damage deposit. However, with that being said, there's another step that people often miss. What it is, it's called a condition inspection report. And what that is, it's a walkthrough with a tenant. You got to do a walkthrough with a tenant, and then you've got to give the tenant a copy of that as well.
So you're looking for damage to walls.
Exactly.
Or this light doesn't work or something,
Yeah,
that kind of stuff.
So I mean, like for example, let's say you rent out a unit and essentially you don't do that walkthrough, and it's a brand new unit, you just purchased it, and you know there's nothing wrong with it, and then you don't do the condition inspection report, and at the end of the tenancy you find out, you do a walkthrough and you're like, oh, this wall's damaged, that wall's damaged, the stove is damaged, right? And there's substantial repairs that need to be done. You can't go and withhold that damage deposit then. So I mean, if you don't do the condition inspection report, you effectively lose your ability to withhold that damage deposit. So I've had situations too where that's happened, right? And
yeah,
it's not ideal, because then you're having to make another application just for these damages, right? So I mean, it's all a long process, but that would save a lot of these landlords like a extra step and having to make another application, right? So it's
can you
important
still
to get that.
Get your damages even without an inspection report?
Like you can make like a dispute to the Residential Tenancy Board for the damage that's caused.
Okay.
Right, but with that, it's a longer process, and then who knows, are you going to be able to collect this money as well, right?
Well,
but when you have the money already and you're holding it, then you know, okay, well, the money's already there, right? So I mean, another couple key points that I would raise, some of the tips would be just obviously communicate everything clearly, keep everything in writing, keep good records. You want to have your bank records readily available. And then just like those previous tips I gave, like if rent's paid late, make sure you indicate to the tenant that the rent is due on the 1st and this is late rent. And then it's very important to just double check, even when you're issuing those eviction notices. You got to make sure, okay, are the dates correct? Are the grounds which I'm pursuing this eviction notice correct, right? And is this a proper form, and am I serving them in time, right? So there's all these little things that you have to pay close attention to, right?
Yeah.
Yeah.
Well, and you've been pretty successful, I think, haven't you?
Yeah, I know for sure. I've definitely helped out a lot of landlords, and then as well as some tenants as well.
Yeah.
Right. So I mean, I've been on both sides, but yeah. So it's frustrating to see. I mean, I just want to be there to just help people, just because it's difficult, because I've had files where it's like a new couple, they're trying to move ahead, they buy a rental property, and all of a sudden they're not getting paid, right? And it's like, it sucks, because now they have to take care of their own mortgage, their family, and where they thought this rental property would be bringing them income, right? And then effectively now they're on the hook for both, and then like they want to now they want to sell the property because they've had such a bad experience with this, right?
Yeah,
so
they got to get it dealt with quickly.
Yeah.
So that's good. All right, we're running out of time, but I want you to finish up and tell us, because I see on your notes here you've got some real world horror stories, and I'm sure our listeners are going to want to hear about that. So.
Yeah, I know for sure. So yeah, with those ones, like, I mean, a common one that we see a lot is you go through this whole RTB procedure, and as a landlord, you essentially you do the hearing, you get an RTB order of possession that states the tenant needs to be out by a certain date. You go and serve that on the tenant, right? And the tenant still doesn't leave, right? Where does that leave the landlord, right? It's not the best situation, but what happens then is the landlord will have to go and get a court-appointed bailiff. They'll have to file for a writ of possession with the Supreme Court.
Oh boy.
And this can be very costly, right? So they get a bailiff. Bailiff shows up at the house, goes into the house, starts removing everything, like whether or not the tenant wants to stay there.
Well, these are the things we read about nowadays, you know, these horror stories that tenants just won't go.
Yeah, and it's tough too, because it's very expensive as well. Like getting that bailiff in there can cost anywhere from $4,000 to $6,000, maybe more. It just
Wow.
depends how big the unit is, how much stuff is in there, how many hours they're going to spend there. And then you can only get a court-appointed bailiff. So there's not a whole lot available, right? So, I mean, it's very costly. So it can be...
And it could take some time, I'll bet, to work it into their schedule as well,
Yeah,
right?
yeah. So, I mean, they're pretty quick with it. But, I mean, with that, too, it can take a few days. And, I mean, people want to get the tenants out. And, I mean, if you don't effectively get them out right away, another thing that can happen is they can apply for a stay of the RTB order, of the eviction order.
But Supreme Court.
Yeah, Supreme Court. So they'd file a judicial review and then seek a stay of the RTB order until that judicial review has been finalized. And effectively,
Do they get it? I mean,
so I mean,
judges are pretty smart. So.
I mean, I've seen it where they do get it, right? And if they have some valid grounds, I mean, especially if it's like a short notice application and the tenants the landlord can't even show up, or they're not able to obtain counsel in time, right? And it's only the tenant there, so it happens more often than you would think.
Yeah.
Right.
Geez.
And then effectively, like, the tenancy is now extended by another 3-4 months until the judicial review, which is effectively like an appeal, right? It's complete.
So just playing the system, really. It sounds
Yeah.
like
So
somewhat.
and then
Unless they've got grounds, I guess.
Yeah.
I should be careful.
And then, I mean, some of the times, like, rent's still not being paid, right? And it's like, how are you going to evict them? Your RTB order is now, there's a effective stay order on there. So, like, what are you going to do? They're not paying rent.
Yeah.
How are you going to get them to pay rent now, right? So it's definitely very scary to be a landlord in some of these situations. But, I mean, if you have the right guidance and taking the right steps and whatnot, then there's definitely effective ways to approach this.
All right. We're running out of time. Give us some closing thoughts.
Yes, I mean, overall, I would say just make sure you keep everything documented. It's important to it's important to get in touch with us early on, and myself early on. I mean, even if you're just wanting some advice, we can sit down for initial consultation, and I can give you some guidance throughout the process.
Mm-hmm.
But it's very important just to make sure that you're doing things correctly and you're doing things the way the RTB wants it, just so you're not finding yourself in a situation where the eviction is effectively taking you 6 months as opposed to where it should have taken you a month and a half or 2 months.
Yeah, how frustrating. Thank you, Abu, for coming on, and I'm sure our listeners got a lot of value out of that. Until next time.